How long in your life have you been homeless?
Maybe like 10 years, sir.
Any particular reason why?
I'm an adult, Corona hit, and I became homeless.
You're homeless because you wanted to be homeless. Court is going to sentence you to... All right, the court is going to sentence you to 8 years in the prison. I'm not following that plea.
Today's session features two separate courtroom cases, and both take unexpected turns. In the first matter, a defendant presents a confident explanation of events, clearly expecting it to carry weight. However, the presiding judge quickly recognizes inconsistencies and addresses them almost immediately, preventing the narrative from gaining traction. The second case moves into far more serious territory. Due to the nature of the details involved, certain elements must be handled carefully and limited from view. What stands out is not just the severity of the allegations, but the tone with which the defendant approaches the court, seemingly unaware of how closely their statements are being evaluated. What makes both cases compelling is the shared moment of realization. Each individual enters a courtroom anticipating a favorable outcome, only to discover that the court sees the situation very differently. When the judge steps in and reframes the reality of the case, the shift is immediate and unmistakable. Although the circumstances differ, both cases reveal a similar pattern, an expectation of leniency without accountability. The rulings serve as a clear reminder that courts operate on facts, responsibility, and lawful reasoning, not assumptions or entitlement. In that sense, these moments act as a firm reality check. Now I want to hear from you. Do you believe either defendant warranted special consideration, or did the court respond appropriately given the facts presented? Share your thoughts, and let's move forward to see how these cases unfold.
Specifically, the TAP does not show that any drug treatment is necessary at this time. Would you agree with that?
Yes, sir.
You don't have a substance abuse disorder?
No, sir.
Is there anything else you want the court to know?
No, sir.
I'll pass. Stay silent and I'll pass the witness.
State, do you have any questions?
Just briefly, Your Honor. Mr. Jargo, the two times that you were given felony probation, you were given probation, but then you were revoked off your probation. Is that correct? Wow. One in 2009 for burglary of a building. Do you recall that?
I can't remember what I think it was before.
And then also evading arrest second, back in 2014. You were revoked in 2014 and revoked in 2009. Do you recall that?
I can't remember. Yes, sir. I think so.
Thank you. No further questions, Your Honor.
No questions, Karen.
All right, I have a few questions. What gang are they alleging that you belong to?
Oh, they're trying to say I'm a Sureño.
Why would they say that?
13, because they said I had a 13 on my stomach. They said I was a Sureño, but I'm not.
What's significant about the number 13 for you that you would tattoo it on your stomach?
It's just I don't got it tattooed. It was just like a number I got when I was younger. But it's like a lucky number. It's not a gang thing. Like it's different stuff. It's just a number for like my
So
name.
why all the numbers would you put that on there?
Because it's for my name, Matthew. It's M2 for middle initial Matthew. Just a lucky number 13. I'm not affiliated, Your Honor.
Yeah, I don't know many people who just put 13 on their bodies because they think it's lucky. Unless they're gambling, and I don't think 13 is a lucky number when you gamble. All right. So why is it you can't hold a job for longer than 6 months?
Because I was trying to apply for SSI checks, Your Honor.
SSI for what?
Mental disability. When I was in school, I was getting SSI checks. I was in behavior improvement special ed classes when I was growing up.
There are a lot of people who are in special ed classes. They don't qualify for SSI. So again, we're back to this point because what you told your attorney was COVID hit and all these other things happened. And that is why you were homeless.
Yes, Your Honor.
But I don't know how you can not be homeless if you're only working 6 months at a time. So again, we're back to the question of why is the longest job you've ever had has been for 6 months?
Because I had it for 6 months and then I stopped and just became homeless.
So basically your homelessness was a choice because you stopped working at at whatever job you had. You stopped working at 6 months.
I tried to get SSI too, Your Honor.
No, you don't. So what ends up happening is you have a job for 6 months. Did you have a bank account?
Oh, Your Honor.
So you have a job for 6 months, you have no savings, and you decide to quit your job in the hopes of getting SSI.
Yes, Your Honor.
You don't, and you end up homeless.
Yeah, I didn't get it because they had me on hold. They said I signed out the papers and everything, but they said it would take anywhere from like a year. I was waiting for like a year, Your Honor.
All right, so Mr. Drago, I'm focusing on why you're homeless, because you're making it seem as though you're homeless because things happened to you, not because you did certain things. So it appears to the court, and I want you to correct me if I'm wrong, you're homeless because you wanted to be homeless. You had a job, you have been working it for 6 months, you decide to quit that job, you have no money in your bank account, and so you just become homeless.
Because I thought I had corona, but I didn't have it, Your Honor.
So you didn't have corona,
Yeah.
so then that excuse is out the window.
That's when I got in trouble.
So you were just homeless basically because you wanted to be homeless.
Yes, Your Honor.
Now let's get to the next question. So the complainants in this case, were they eating at a restaurant?
No, Your Honor, they're pulling up to a restaurant.
All right, so they're pulling up to a restaurant and you disturb them, asking them for money to support you, right?
Yes, Your Honor.
Because you're homeless and you don't want to work. So you want to get money from people who are trying to just go to a restaurant and enjoy their meal in peace, right?
Yes, Your Honor.
Now, how old is your mother?
My mother, she's like 50 something. I'm not so sure, Your Honor.
All right, so you don't know how old your mother is. What's her date of birth?
I don't know, Your Honor.
Do you know what month she was born in?
Oh, Your Honor.
Do you know what day it is?
It's 4/27.
So you're saying she was born in April?
I don't know, Your Honor. I don't know when she was born. I don't know. She's like 56, 57.
How old are you?
Me, I'm
It's
37.
difficult to take this explanation at face value. The timeline alone raises immediate concerns. The defendant attempts to explain a decade-long situation by pointing to circumstances that simply do not align with the dates involved. When details don't match basic facts, it signals to the court that responsibility may not be the priority here. Behavior in the courtroom adds another layer to the issue. Body language, posture, and attitude all matter, and in this case, the presentation suggests an expectation rather than an understanding. Probation is being treated as something owed rather than what it actually is, a structured agreement with a court that comes with strict conditions and clear consequences. Probation is not an informal arrangement or a reset button. It is a conditional opportunity, and violations don't lead back to negotiations. They often result in incarceration. That reality does not seem fully understood here, or at least not taken seriously, which is concerning given the stakes involved. Based on what we're seeing, it's hard to imagine a smooth outcome if probation were granted. There's an impression that rules are viewed as flexible rather than binding, and that mindset tends to create problems quickly. Courts look for accountability and effort, not resistance or dismissal responsibility. What's interesting is that the presiding judge is known for offering multiple opportunities when she believes progress is possible. Whether that approach is always effective is open to debate, but it's clear that patience has limits. Continued explanations that lack credibility only weaken the defendant's position further. From this perspective, it appears that each additional comment may be doing more harm than good. The question now is whether this explanation is convincing anyone at all, or the court is simply allowing the narrative to continue until its flaws become undeniable. What do you think? Is this strategy working, or is it proving the judge's concerns?
All right. Is there anything else you wish to say, Mr. Idrago?
No, Your Honor.
All right. The court is going to find you guilty in count 1 and count 2. Court is going to sentence you to 5 years in the prison in each count. Each count will run concurrent. Give you credit for any time served. There's an affirmative finding of a deadly weapon. All right, we can go off the record. Mr. Idrago, when you get out, you need to make better choices. Get employed. If we want stuff, we have to work for it. I know people think it's okay to come up to people and ask them for money, but sometimes people don't want to be bothered. They're just trying to spend time with their family. You understand?
Yeah.
Good luck. And are you David Newman? Are both parties ready to proceed on this motion to revoke? Are you the same David Matthew Newman who was placed on community supervision in 2021 CR 0689 for the offense of possession of on February 1st, 2022 for a term of 10 years? Is that you?
The defendant, David Matthew Newman, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department program, and that the defendant failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, and that the defendant was suspended from treatment for failing to abide by treatment program rules in violation of Condition 13B.
How do you plead to that? True or not true? True, ma'am. State.
In Condition 13H, on or about the 12th day of September 2022 in Bexar County, Texas, the defendant, David Matthew Newman, did then and there fail to comply with the instructions of the Bexar County Community Supervisions and Corrections Department program, and that the defendant was in possession of materials in violation of Condition 13H.
How do you plead to that? True or not true? State.
And lastly, the state is proceeding under Condition 16 on or about the 21st day of September 2022 in Bexar County, Texas. The defendant, David Matthew Newman, failed to comply with Chapter 62 requirements in violation of Condition 16.
How do you plead to that? True or not true? Mm-hmm. Did you understand by pleading true to violations 13B, 13H, and 16, the court could find it true, grant the motion, sentence you to 10 years in the prison, and up to a $1,500 fine? Did you understand?
I understand.
Knowing that, do you still wish to plead true to 13B, 13H, and 16?
Yes, ma'am.
Court will find 13B, 13H, and 16 true. Is there an agreement?
There is an agreement, Your Honor.
And what is the agreement?
Revocation and a sentence of 6 years TDC.
That is correct, Your Honor.
All right. With regards to allegation number 16, is that a different type of?
That is non-contraband, not child pornography.
Okay. Adult?
Yes, ma'am.
All right. The court is going to grant the motion, revoke you, sentence you to 8 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. There's to be Chapter 62 registration. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right. You have a limited right to appeal, and that's as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand? All right. Good luck to you.
Sure.
Yes.
The deal was for 6 years, and I believe you announced 8. Is that?
Yes. I'm not following that plea. Okay. Thank you.
This moment in the hearing is particularly revealing. The defendant states that, if granted probation, he would live with his mother. However, when the court asks simple follow-up questions, basic personal details that would normally be easy to answer, he struggles to respond. Judges pay close attention to these small details because they help determine whether a proposed plan is genuine or simply stated for convenience. The probation plan must be realistic, verified, and thoughtfully considered. When someone suggests living with a family member, the court expects that arrangement to have been discussed and agreed upon in advance. The uncertainty shown here raises serious doubts about whether this option actually exists or was ever confirmed. IT is fair to acknowledge that courtrooms can be stressful. Some individuals freeze under pressure and momentarily forget information they know well. Nervousness alone does not automatically mean dishonesty. That said, when this hesitation is combined with earlier inconsistencies in the defendant's statements, it becomes harder for the court to view the explanation as reliable. The overall presentation suggests a lack of preparation and planning. Probation is not granted based on promises alone. It depends on stability, accountability, and a clear path forward. Without those elements, the court has little reason to believe the conditions of supervision will be followed successfully. Judges see these situations frequently. When responsibility is avoided and effort appears minimal, the same issues tend to repeat, often resulting in a return to court. That pattern is exactly what probation is designed to prevent. What's your take? Should the judge have explored this explanation further? Or was it reasonable to recognize the weaknesses and move on? Share your thoughts as we continue examining how this case develops.
How long in your life have you been homeless?
Maybe like 10 years, sir.
Any particular reason why?
I'm an adult, a corona hit, and I became homeless.
You're homeless because you wanted to be homeless. Court is going to sentence you to. All right, the court is going to sentence you to 8 years in the prison. I'm not following that plea.
What this courtroom session makes very clear is that attempts to test boundaries or manipulate the process rarely end well. In both cases presented today, the outcomes were firm and decisive. In the first matter, the court quickly addressed inconsistencies and made it clear that unsupported explanations would not carry weight. The second case took a much more serious turn. What began as a difficult situation escalated rapidly, and the final outcome reflected the gravity of the charges involved. A proposed agreement of 6 years had been discussed, yet the judge ultimately imposed a longer sentence. The moment that decision was announced, the shift in the defendant expression made it clear that the reality of the ruling had fully set in. Judges consider more than just the written facts. Courtroom conduct, demeanor, and respect for the process all factor into how a case is perceived. When a defendant appears dismissive, uncomfortable, or inattentive to the seriousness of the moment, it can influence how the court evaluates credibility and accountability. Point one key principle stands out here. Courts do not respond well to behavior that suggests the process is not being taken seriously. Respect for the court is not symbolic. It reflects an understanding of the situation and the consequences involved. When that respect is absent, leniency becomes far less likely. Looking at the broader picture, the rulings in both cases send a consistent message. Accountability matters, preparation matters, and the courtroom is not a place of performance or deflection. The justice system prioritizes responsibility and lawful reasoning above all else. Now I'd like to hear your perspective. Do you believe the court's decisions were appropriate given the circumstances? Or do you feel the outcomes were too severe? Share your thoughts below, and thank you for watching and engaging with the discussion.